So we a little bit discussed about the judges and their role in the jurisdiction. And now let's try to define how the actual doctrine of precedent is working. If you could tell us a little bit in plain English, what is the doctrine of precedent and what are the main points there?
So precedent is a concept that we have from something called stare decisis, which means to stand by the decision. So what we want in any system of law is to have consistency and certainty for the sake of fairness. The decisions should all be consistent. Everybody should be treated the same. And we should have certainty in that we know where we stand. We can't really be expected to follow a law if it changes and is incredibly subjective. So the way we do this is that we have a hierarchy of courts in the UK. And as we can see on the slide, we have a superior court. So at the top, we have the UK Supreme Court. And the decisions that are made higher up tend to need to be followed then by the courts that are lower down, the inferior courts. So as we see, decisions in superior courts need to be followed by inferior courts. We have some exceptions the higher up we go. So at the top, where we have the UK Supreme Court, they are not bound by their own decisions. We follow a rule actually that used to apply to the House of Lords. So the House of Lords at one point, after the late 19th century, were bound by their own decisions in something called the London Tramways Rule. That changed in 1966 when we had a practice statement to say they no longer had to follow their own decisions. The Court of Appeal is generally bound by their own decisions. They can depart from those decisions in certain situations, which we have back on the slide in Young v. Bristol Aeroplane. So 3 exceptions here. If there's conflicting decisions, they obviously cannot follow both of those decisions. There's another exception if, in their opinion, the previous decision cannot stand with a decision of what was the House of Lords, now the Supreme Court, and another where the previous decision is believed to have been made per incuriam. So effectively, with some kind of defect, it was a mistake in some way.
Thank you very much. So if judges do not want to follow a particular decision, they still have some options, right?
Limited options, yes. So if, for example, I was a judge making a decision in one of the lower courts, if I was in the Crown Court and there was a similar case that was heard in the Supreme Court, I would be bound to follow the decision made in the Supreme Court unless I could distinguish my case in some way. If I could find a key difference, for example, in the facts of my case that made it different from that case, I could say they're not the same and I do not need to follow that decision. My case is different enough that I can make a new decision.
And then we see this treatment like distinguished or applied. This is where it's coming from, actually.
Yes. Yeah, absolutely.
Thank you very much.